Probably about 30 seconds until we get started here. Give people right till noon to get in sometimes. Takes a minute to sign in. But I'm glad you're all here. I'm glad you all are concerned about this law and how we can all best deal with it. Like many things in trucking, the law is things we deal with. It's not necessarily something we embrace, but part of being compliant. The DOT is enough fun. You don't want Department of Labor in your life either. All right. Okay, we're going to get started. Again, if you have any questions as we go through this webinar, there's a questions panel in your control panel from the Go to Webinar tab. Type your questions in there. We'll do our best to answer them. And if we can't answer them during the webinar, we'll try and answer them after the fact. So welcome. Today's webinar is about the Michigan paid leave law that starts tomorrow. There were a number of changes as well that start tomorrow. Minimum wage goes up 20 cents, I believe it is. But this is the big one that's going to affect us. So let's start into this. Make my truck drive away. Okay, a little bit about me. I'm the founder of Superior Trucking Payroll Service. I've been doing payroll for a while. I've worked with trucking companies and worked for trucking companies for the better part of the last 20 years. And I'm in a bunch of associations. That's all well and good. A little bit about our company. We're a full service payroll provider. We do everything everybody else does, but we do it with a trucking focus. We understand the difference between a lumper and driver unload, things like that. We know that you're going to have advances. We understand per diem and how that can save you money. So there's a little bit about us. We're happy to help you if you're not already one of our clients. And if you are, that's awesome too. So thanks for coming. In today's webinar, we're going to talk about these topics. What is the law that we're dealing with? To which employers and employees is this law going to change our lives? And how do we best accommodate this law, make sure that we're legal? And then what traps for trucking companies? Because there's a couple of traps that we found that I'm like, ugh, this could be trouble. So we'll talk about those. What do we do next? And always questions and answers. Again, any questions, type them in the box anytime you have them. We'll get to them at the end. Here's my mega disclaimer. I am not an attorney. You're going to hear me say this probably 15 times today. I'm not licensed to provide legal advice. There are actual attorneys who are licensed and pass bar exams and things like that to provide you legal advice. That's not me. I stress this because citing this webinar as a way of, well, Mike said something, the court's not going to care, and coming back after me is not going to do you any good. So there are attorneys for these things. And so I would urge you to consult one if you've got matters that require this. All this webinar is about what I've seen so far and where I think things are going, but I'm not an attorney, and we'll get into more of that. But I just want to make sure everybody knows, this is kind of where we're coming from. There's a lot of this that's unsettled at this point. So you're going to see on the bottom of every slide, I'm not an attorney. Here's the law. It's enrolled Senate Bill number 1175, amended from 2018, Public Act 338. I put the link in there. I put the link at the end of the thing too. It's really about a 4-page PDF, which for a law is not very long. They refer to it as the Paid Medical Leave Act. That's the short name for it instead of enrolled Senate Bill, blah, blah, blah. These are the guts of it, and I'm not covering everything, but I think this is the part that's going to matter. Employers must accrue 1 hour of paid medical leave for every 35 hours worked by an employee in the week. You only have to accrue 1 hour per week for the employee. If they work 70 hours, you don't have to accrue 2. Employees can have up to 40 hours per year accrued for them. You're not required to accrue beyond that. The employees can carry over 40 hours, so it's not, if we used calendar year as an example, if they had 40 hours saved up on New Year's Eve, but the New Year's Day they don't start at 0 again. Oh, sorry, you were sick on New Year's Day. That's a bummer. You have no sick time. You have to be able to carry over one set of 40 hours, but the employee can only use up to 40 hours in a year. So if they went through year one and used no sick time and earned 40 hours and then carried those over, and then in year two earned another 40 hours, which they would earn if they were full time first week in October. And then in November they got sick, they couldn't use 80 hours that year. They'd only be allowed to use 40, unless of course your policy allows them to use more. There's other things in here too that we're not going to go into, like what they can use medical leave for. Basically, it's domestic violence issues and health issues, including mental health issues. So it gets into definitions that are taking or a family member, and they go through great length to define a family member. That's to me is not really it's not the important part of this. We can talk about it if you ever want to, but that's not the crux of this. The main part is you got to accrue time, and this is how they can use it. Which employers are subject to this law? Well, employers under 50 employees are exempt from this law. So if you have less than 50 employees, hooray for you. You don't have to deal with this. But the trick is, it's not 50 Michigan employees. So if you had a company that had, 40 employees in Indianapolis and 14 in Michigan, your 14 in Michigan are subject to the law. If you're an employer with 200 employees in Texas and one in Michigan, that one employee is covered by this law. If you're at 48 or 49 employees, you want to be careful with look back periods and things like that. So 50 may be coming. You just want to be mindful of that. So if you're at 12, then I wouldn't really sweat it. But if you're at 45, I'd be really kind of paying attention to this. And if you're over 50, and again, that's throughout the country, then this applies to you. Nothing in there I saw about control groups and things like that, but I would imagine that stuff exists as well. I'm not sure about that, but if you had 5 companies that each employed 10 people, you could be looked at as counting as 50. So again, just be mindful of that. I don't know that anybody has that issue now that signed up for the webinar, but that could be you. So if your group employs 50 people, prepare to be subject to this law for your Michigan employees. Here's the fun part. To which employees does this law apply? There are 12 exemptions. It applies to all employees except for, and they list off 12 exemptions. Most of them don't matter to us. Employed by a governmental unit. The state nicely exempted themselves from this law, which I thought was kind of funny. Or U.S. government or townships and stuff like that. None of that applies to us. Working on a ground crew of an airplane, of an airline, you're exempted. There's some railway things that are exempted. I went and looked up the laws. They don't roll over into trucking. The salaried exemption, this first one here, exempt employees that are salaried under 13A1 of the Fair Labor Standards Act. That's the salary exemption for administrative and executive and sales people. The people that are traditionally salaried, they're exempt from overtime. As we all know, truck drivers are exempt from overtime when they're interstate, but that's not under this exemption. So don't go thinking, oh, because truck drivers are exempt, so I don't have to deal with it. Now, that's not how we're going to get out of this one. So it does apply, all your salaried, what people typically call salaried employees aren't covered by this, which seems like an odd exemption to me, but we'll take it. Then there's employees that work less than 25 hours a week on average, or work less than 25 weeks in the immediately preceding calendar year. Those less than 25 weeks, though, that's not new hires. That's people who worked for you all year, but worked basically every other week. You can't be like, oh, I hired this guy in August, and so he only had 20 weeks in by the end of the year. No. Those guys count. It's the people that had worked for you the entirety of the year and worked less than 25 weeks. Those are the ones you might be able to get exemptions on. Similarly, employees that work less than 25 hours per week on average. This is kind of a tricky one for trucking because a lot of trucking companies don't track hours of their drivers. Now, I think we can all agree that if you're letting them, unless you're slip seating them, they're probably working more than 25 hours. But you can't just say, oh, we don't check time on that. That won't get you anywhere. Especially your over-the-road guys. Those guys, they all work more than 25 hours a week. We have laws to limit their hours. So I don't think that's really going to be a big issue. But You can get some people out with this one. Now the last one, an individual whose primary work location is not in this state. There are two schools of thought on this that I had immediately. One of them is, what is the primary work location for an over-the-road driver? And typically, like for tax things, there's a list of qualifications about how you would do it. And for those of you who have a single terminal in Michigan or have only terminals in Michigan, that most of the time, even if the driver lived in North Carolina, Michigan would be considered their primary work location. That's why we tax them with Michigan withholding, because they're considered to be Michigan employees. I the other option, the other idea would be that, well, look, they spend 8% of their time in Michigan, and then 2% in Indiana, and whatever, all the way down to California or wherever they go, or to Florida, or wherever you send your drivers. And so they really don't have a primary work location, or if they do, they're in other states as much as this one. So I called the state of Michigan about this just this week because I thought they were going to really stick it to us on this. I talked to Troy at the Licensing and Regulatory Affairs. He's one of the managers there. Lara, which is Licensing and Regulatory Affairs, they're the people that are going to administrate all this. When an employee files a complaint with wage and hour that I wasn't paid for my sick time, they're going to these guys. They're going to Lara with this. Lara also does unemployment, just as a frame of reference. So I talked to Troy, who's a manager there, and I asked him some questions. And one of the things I asked him was about this individual whose primary work location is not in this state. And he said that they have to spend more than 50% of their 50% or more of their time working in Michigan to be considered primary work location. And to me, primary means most, like first. It doesn't mean majority, but I asked him to repeat it. I talked to him, had him clarify it, and he said, "Look, if you can demonstrate that they don't work half their time in Michigan, we're gonna reject the complaint from the employee." Which I'm like, hooray! That is surprisingly good news for our clients that have to, and other trucking companies, they have to try and deal with this law. I will caution you in a little bit about this, the lining of the storm that could be coming anyway. Basically, that's Troy's opinion, and he's the manager, and he's been told how to handle this law. But it's the court that interprets the law. And so what I envision happening is there's going to be an employee who files a complaint against a trucking company. The trucking company is going to say, look, his primary work location was not in Michigan because he only rode 10% of his miles in Michigan. It's going to go to the court because when the employee's claim gets denied, they're going to keep pursuing the matter. And that's where it's really going to get decided what primary work location means. Originally, just as a little background for this law, there was a law this was an amendment of a previous law, and the previous law was written in September of last year. It was much more comprehensive. It applied to all employers, regardless of size. It was up to, I think, 72 hours or something like that, a year of bankable sick time. You accrued it more quickly. There was a lot of other stuff in there. Minimum wage, which was also a part of this, expanded more quickly. And so there were a lot of things there. And in that original rule, Lara, Licensing and Regulatory Affairs, had rulemaking ability on this, and they could basically set all these rules, and then it would have been much more final. And Troy over at Lara could have told me exactly what was going to go down. But he's like, no, we lost rulemaking ability in the amendment. We don't have that anymore. So I think it's going to be the courts that decide this. But in the meantime, it's a pretty good defense that you don't have to provide this to drivers that are over the road, which was the best news I heard all day that day. One of the other things that I would also caution people, trucking companies, about is don't get cute with that 50%. For example, if you were a Kalamazoo Battle Creek trucking company and your driver goes to South Bend, and let's say because of the stops, he's got 52% of his miles in Indiana and only 48% in Michigan, I don't know that the state is going to accept that as proof, because we don't know how long things take to load. We don't know any of that stuff, and they're going to want to measure time. and not miles. Now, I think we're good with a claim to Florida, because only however many percent of the miles are going to be in Michigan, and you can clearly demonstrate all this time that goes out there. But for something that's even close, I would caution you to be tracking time and not necessarily using miles to do this. Just something to keep in mind. And again, all this stuff has not been adjudicated. So until the Michigan Supreme Court basically decides how this is going to go down, we're just all doing our best to try and figure it out, which is probably why you don't see a lot of webinars about this. I've been looking for other webinars to go watch. I haven't seen them. I found one that was a pay webinar, and I didn't even do that, but just because nobody knows. So again, the over-the-road drivers may not be subject to this law because of the primary work location exemption. How do we comply with this law? So we're going to have some employees that are still going to be subject to this law, hourly people specifically that are not over-the-road truck drivers, your local drivers, your shop guys, because even though shop guys, again, can be exempt from overtime, with the trucking exemption, they're not exempt from this law because that's a different part of the FLSA exemption. Quoting from the state, paid medical leave must be paid at a rate equal to the greater of the employee's regular rate of pay or the Michigan minimum wage rate. Figuring out the employee's regular rate of pay for a local driver, hopefully if you're paying them by the hour, no worries, we got it worked out, right? If you're paying them mileage, we're gonna have to work backwards to regular rate of pay, which would also be, again, tracking miles or tracking hours and miles. So that's just something to be aware of, but you've got to figure out a regular rate of pay. Most of you do that anyway. So I don't think it's a huge obstacle, but it's something to consider. You also you need to accrue the pay each pay period. These hours accrue. So if you pay every week, which most of you do, most trucking companies do, you got to give them an hour a week. If anybody who works 35 hours that's not exempt gets an hour a week. The next line I put in there, accrue 1 hour for drivers for each week of their work. That's if you're going to give this if you have drivers that don't have hourly, like you're not paying them by the hour. If you're paying them by the mile, but 50% or more of their hours could be in Michigan, I would say, and you don't want to track their hours because you're paying them mileage, I would just give them the 1 hour a week. I wouldn't quibble about this. They're probably working more than 35 hours anyway. And do you really want to get hung up on something this silly? We only worked 32 hours that week, so I only owe him 32/35 of an hour. You're talking about 6 minutes. I would just accrue the hour for him. Do you really want to make them mad over 6 minutes anyway? So you're talking like $1.50 or something, depending on their hourly rate. I would just accrue them for them. Now, most of you aren't going to have this issue because you're either paying them by the hour or they're not Michigan drivers or primary work state of Michigan drivers because they're over the road. But if you fall into that crack, I just give them the hour every week. One of the things that we do for our clients that have 401k plans is 401k plans require hours to make sure that they're allowed to be in the plan. Usually it's 1,000 hours a year. Plans vary though. What we do for a driver is if the driver worked, we consider it 40 hours because they're working more than that most weeks anyway. And so even if we pay anything, they just get credit for 40 hours, and every 401k company's never had a problem with that. So it's kind of the same theory here that we'd give them the hour of sick time for the first 40 weeks of the year. One way you can get out in front of all of this is to front load vacation time. Or front load time, I mean. Like give them 40 hours right at the front of every benefit year. If you do that and you give it to all the eligible employees, you don't have to keep track of anything. Now you might be thinking to yourself, well, 40 hours times their hourly rate times my number of employees plus payroll taxes and all that fun stuff. It's easy for me to give away thousands and tens of thousands or hundreds of thousands of your dollars, and you're right, it is. But we've got another way to help with that here. But the point of this is that it eases the administrative burden, which is really, to me, one of the bigger parts of this. Not only do you have to pay the vacation, but now you got to pay the paid time off, but you've got to keep track of it all and keep track of how they accrue it and all that kind of stuff. But if you front load everybody, you can reduce the administrative burden. Here's a great, this is right from the state of Michigan, right from Lara. I can let you read it, but basically what it says is that if you're giving somebody 40 hours of paid time off, vacation days, personal days, whatever, that can count as your sick time. You don't have to give this to them in addition to the vacation you're already giving them, if you're already giving them at least 40 hours of paid time off during the year. So that's really nice because I think a lot of trucking companies that I talk to were really concerned about this. Like, okay, I'm already giving them a week or 2 weeks or 3 weeks or whatever you give them for vacation, and now I got to give them another week on top of that. And so again, you're doing the math of, call it $1,000 a week per driver times how many drivers you have. I'm like, if I have 50 drivers, which you probably would be close to that to be part of this law, yeah, that's 50 grand. That just went out the door on me. Well, no, not necessarily. Uh, and I copied and pasted this right off of their website, and I've got the link for this that I'm going to provide for you in a little bit. But it's, and I asked Troy over at Lara about this. I'm like, so I'm understanding that I can use vacation time. That would count if I roll up 40 hours of vacation on somebody. That counts for the paid time off. And he goes, yeah. The main thing is you got to let them use it for the sick time uses. Uh, you got to let them use their vacation for it. And I don't know anybody who'd have a problem with that anyway. But you just make sure that you're compliant with that side, and you're good. So you don't have to load up extra time once the employees are in vacation hours. And again, with the drivers, we've got rid of all the over-the-road drivers for the most part on this anyway. So we're really reducing the financial impact. Well, the state is. I'm not doing anything. The state's reducing the financial impact on you by things you're already doing, which is a considerable relief and a surprise that the state wouldn't try and get you. So, and again, I'm still not an attorney. That's in all the slides. Here's some traps that I've found when reading through this. The first one is exempt employees, because they're not part of this plan. They're not covered. You're not required to provide paid medical time for them. I'm concerned that there's a lot of trucking companies that have employees that are treated as if they're exempt, treated as if they're salaried employees, but if the government came to make the determination, they would not be considered exempt employees. They would not be. They would be allowed to get overtime. I've had a number of clients who've gone through lawsuits because they had a dispatcher quit or got fired or whatever, and then the dispatcher came back and said, "Well, I was on call every night, and so I was really working 70 hours a week, and so I'm owed 30 hours of time and a half pay for every week. Actually, I'm owed the 30 hours of time and a half for each week I worked there for the last 4 years or whatever thing it was." And ultimately, in each of the cases, the trucking company had to settle because it was going to go to trial. And part of why they had to settle was they weren't tracking the time of their other people they were considering exempt. So when the former employee said, "I worked 70 hours," the employer had nothing that they could do to rebut that and say, "No, look, he or she filled out a timesheet for 42 and a half hours last week and signed it. That's what they worked." Now they're saying 3.5 years later they worked 70 hours. Well, no, it's not our fault that they falsified documents, and we tell them specifically not to falsify documents. Um, so that's the first thing that I would be worried about, that because now if they're determined to be not exempt, now they're also eligible for this sick time, and that could blow up in your face. And this exempt versus non-exempt, especially for the dispatchers, I've talked to attorneys that specialize in trucking, and they've said that, oh yeah, dispatchers aren't exempt, and I tried to make the case that they were, and they're like, nope, now they're just doing things in the normal course of business. They're not given the authority to do the things that would make you an exempt employee under one of the exemptions. And every case I've seen that my clients have gone through ultimately ends up in a settlement because the trial would be so expensive, but they were going to get the trial because the evidence was leaning that way. So just be really mindful about this dispatcher thing, especially about exempt versus non-exempt. And even if you're going to choose to treat them as exempt employees and pay them a salary, track their hours anyway. That way, if you do get sued, you can at least have some way to mitigate the cost. Because paying for a couple hours of overtime, all right, fine, whatever. Here's $20, go away. But 30 hours per week for 4 years is a lot, and it adds up quickly. Plus their attorney's fees, plus your attorney's fees to defend it. It's just a nightmare from start to finish. So consider that. The next one I saw was 1099 workers that should be classified as employees. It seems like at some point we're going to have a definitive ruling on this. There's a lot of different tests that a lot of different states use, and as we all know, the political winds shift left and right as we keep going through the years. We have now a governor from the Democratic side, and that will run the executive branch, and so they might step up enforcement again. They might decide that drivers that you're considering are 1099 are going to be considered W-2 employees, especially if they're running your truck and you're paying for the fuel and the maintenance and that stuff. And that happens more than I want to deal with, but those guys and women are going to be considered employees. And so where this comes in is, number one, these people could push you over 50. If you were, I'm at 45 employees and I've always been at 45 employees, but you've got 10 of these 1099 workers that now get considered employees. Now you're responsible for complying with this law. So now you've got a fight on your hands. In addition, these 1099 people could file claims on sick time because you weren't paying 1099 people vacation. So they wouldn't get it that way. And then it just comes into what kind of work they're doing and can you prove they were out of the state, which again, proving this 2 years later is a lot harder. So just be really mindful of that, especially with those 1099 people if they're driving your truck and you're paying the fuel. And many of us would agree those are supposed to be W-2s, and every court would agree to. I mean, there's even crazy stuff like in California. You've probably all heard about this, that a lot of companies are basically firing all their owner operators in California because California has put in a really strict test and wants to turn them all into employees, is the fear. Even owner operators who own their own truck and brought their own truck with them, crazy stuff like that, which we all would agree with are 1099 people. And so like Swift, one of the biggest trucking companies, of course, in the country, got rid of all their, or is getting rid of all of their owner operators in California and encouraging them all to be independents and brokering to them. So it's the issue in that case is that because they run on the same DOT number, the state of California has determined that they're employees, which they have to, as we all know, they have to run under the same DOT number. The DOT requires it. So that'll hopefully all get worked out in the courts without affecting any of us. But just know that this kind of stuff happens, especially, so just be mindful of the 1099s. The last trap that I really wanted to focus on was consistency in the documentation. If your handbook has, here's how you can use sick time, just make sure you follow it. You're opening yourself up to lawsuits here and discrimination lawsuits if you are not applying your rules consistently. It's just an opening, and it's just going to get you in trouble. I quoted here from the Act, usual and customary notice proceed. They list it all out, but basically it's have a plan for this, and one of the things is about the documentation. If you're going to require documentation for every time somebody wants to use sick time, then you better require it for every time anybody wants to use sick time. If you forget a couple of times and you don't keep the documentation, and there's some way that someone can say that's a protected civil right, you're going to lose more times than not. So just be really careful. Just have your plan and then stick to your plan about how you're going to do this. Hopefully I beat that in enough, and I'm still not an attorney. That's still down on the bottom. Now, what do we do next? Okay, we're almost out of time. I'm going to try and get through this. I'll run a little long if people can stick around, but not too long. I like to do these in half an hour. The main thing, and this goes direct to the point I just made, review your paid time off policy in your employee handbook. Update your employee handbooks every year really is the best, and 2 years is stretching it, but everybody can live with it. Make sure your policy manuals are legal and good with everybody, especially employees in the first year. This is when I talk about the time off policies. You're going to have to accrue for time off in the first year if they don't get vacation at hire. Assuming you had a vacation policy for everybody anyway. You're still going to have to deal with people in the first year because they accrue it from the day they start. You don't have to pay it for the first 60 days, but they get to accrue it right from the get-go. So you got to make sure that they have that. It doesn't have to be vacation time. It can be sick time only, but they still get it. So you've got to be accruing that. My next thing is get HR help if you don't have it. If this law applies to you, to your company, you have at least 50 employees. And if you have 50 employees, you should have some HR help. And what I mean by HR help is people or resources. Most of you are going to have people that are HR people. Make sure that they have the resources to to get the help that they need on these things, whether it's tracking tools or someone they can call. Our clients have an HR helpline they can call and get questions answered. Make sure that they have resources. It's so important because this stuff keeps changing all the time, and this law is going to continue to change. The next one is be sure to track your time. Your timekeeping software, if you use timekeeping software for your people, it should be able to accrue this time for you and give them balances whenever they want to see them. There's all kinds of fun stuff it should be able to do for you. Fun is relative, of course. Hope everybody realizes that. But you need to make sure you're accruing this properly. We have timekeeping software that we like to recommend to people, and it does all this, and it's fairly affordable. So give that some thought, because you want to make sure that they can see this, or make sure that if you're using timekeeping software, they should be able to do this. Again, it's an hour for 35 hours, or proportionally down from there, up to 40 hours a year. Make sure that it can handle that. Arizona has a very similar law in a lot of ways, and so all of the big timekeeping systems have dealt with this with Arizona. They should be able to deal with this. If yours can't, let us know. We can connect you with some people. The big thing, stay tuned. This law has not been adjudicated yet. It doesn't even start until tomorrow. We've got 11 and a half more hours before we got to deal with this formally. 11 and a half whole hours. So while I talked to Troy at Lara, and while we've all been doing reading, and you can read the law, it's like I said, it's really only about 3.5 pages to read, and most of that's definition of family member. There's going to be interpretations, because these things are never perfectly written. If all laws were perfectly written and understandable by everyone, we wouldn't need a court system, because everything would be obvious, and it's not. So what's going to happen is there's going to be court cases, and there's going to be trucking ones eventually, that somebody thought they should have got sick time, and Lara said no, and then they went to the courts. It's going to happen. So that's what's really going to set all the rules here. If the court came back and said that, primary work location is determined the same way as tax home, then then the drivers get this. That's just how it is. Lara says right now that they don't, and that's what I'm relying on for now. But at the same time, there's no promise there. There's no guarantee for me on this. So we just gotta be mindful of that, of court cases. Be looking for them. We're going to look for them too, and if we see anything, of course, we're going to blast it out to everybody and put it on our website and stuff like that to try and keep an eye on this. But don't just rely on us to do that. Hopefully, if you find them too, let me know, and I'll spread the word. We're all kind of in this together. So hopefully we can find some favorable court cases. But there'd be another part too, is what if the judge says, oh yeah, the way that Lara ruled it was correct, and that the over-the-road drivers that spend less than 50% of their time in Michigan are not subject to this law. That's great news. Let's all talk about that. And so the last thing was conservatively comply with this law. What I mean by that is, if you're in doubt, make sure you're paying the accruing and paying the sick time. You don't want to be the versus in that lawsuit. You don't want to be, Smith versus Jones Trucking. You don't want to be Jones Trucking. The legal fees would kill you. And so since I imagine most of my clients, or our clients here at Superior Trucking Payroll Service, that are in Michigan and that are subject to this law, most of them have vacation for their drivers, and the market really kind of demands it anyway. So I don't think it's really going to be a big issue, other than keeping track of it, and those first year ones. Those, I think, are going to be the two big obstacles to making sure we don't get in trouble. Because no one wants, Department of Transportation's enough to deal with. You don't want Department of Labor in your business. It's no fun. There's no winners, especially on the company side. Even if you're found to be compliant, there's still no winners. Let's see here. Here's some links. The first link there, and everybody's going to get a copy of the slides, so you don't have to worry too much about writing any of this down. But the first one is the text of the law. If you can't sleep at night, you can start reading through that. The second one is the FA that has FAQ in it. That one is one I cited when I showed you that the vacation policy, the vacation hours would count. And that's a living, as Troy would stress me, he's like, that's kind of a living document. So check it often, check it every time. Don't just save it once and download it and say, well, this is the law forever. because they're going to change it. They changed it between uh, even from beginning of February to now. So they took some questions out and added some questions, and so keep an eye on that. The next one is the wage and hour division. It's basically part of LARA. That's where people are going to go to file complaints. It's also going to probably have the link above it and some other stuff in there. So keep that in mind when you're looking for resources. And then the last one is us. Yeah, we're gonna, as we see stuff, we're gonna try and get the word out to keep everybody in the loop. So check our blog on truckingpayroll.com, and as we find things, we will definitely keep everybody informed as best we can. And likewise, if you see something, send it to us. Put it on our Facebook page, put it on our LinkedIn, email me, email Brandon, somebody, let us know. And we're happy to try and spread the word. Okay, any questions? I know this is a lot, and it's hopefully good news as far as, the drivers are not necessarily eligible if they're over the road, and in addition, the vacation time counting. Those are the two best pieces of news I have for you. But if there's any questions, put them in the question box, or feel free to reach out to me later too. I know I'm already 5 minutes long, so I'm probably not going to take a lot of questions if I take any, but I'm going to give you a minute to put them in there, or you can reach out to me. My email address is right here. There's our blog, there's a Facebook and LinkedIn and all that fun stuff. Twitter at Trucking Payroll. Yeah, nobody ever tweets at me, so that'd be kind of fun. But reach out to us. Let us know how we can help you. If you have questions about the timekeeping, if you have questions about the HR help that we're talking about, let us know. We're happy to try and redirect you there. If any of you know trucking attorneys in Michigan that can speak more authoritatively on these things and are actually licensed to practice law and that kind of fun stuff, have them reach out to me if you don't mind. I will do this webinar again in a week or two with an actual attorney if I get one that is willing to talk about it. I reached out to a few and they were pretty lukewarm about it. My theory, and it's only my theory, is that because the law is not settled yet, they didn't want to do it yet. So they didn't want to put themselves in a box, which I get, but since I'm not an attorney, I don't have to worry about that. Okay, there are some questions that came in, which is awesome. I'm so glad. Let me see if I got to make my thing so I can read them. Oh, let's see here. So I'm sorry, this just takes a second. I'm going to go all the way up to the top here. Are drivers, mechanics, and driver helpers who are exempt from overtime exempt from the paid time off? They are not. The drivers and mechanics and driver helpers, that's section, it's either 18 or 20 of the Fair Labor Standards Act, and that exempts them from overtime. This is specifically section 13A1 that those people are exempted, and that's the administrative and professional exemption and outside salespeople. The other people are not exempt from this act, so you're going to have to give them that. But if you're giving them vacation time already, or PTO, or however you want to define it, then you're covered, except for that first year. You've got to ramp it up for them. Companies, and I'm reading these live, so cut me some slack if I sound confused. Companies that front load the 40 hours do not have to carry over unused balance of paid sick leave. Am I reading that right? Yeah, don't have to carry over any unused balance. That makes sense to me. All right, so far. I'm not sure if that will be mentioned or not. Well, I just mentioned it, Mary, so thank you for bringing that up. Yeah, that's right. If you front load, because they can only use 40 hours in the year anyway, you're good. Another thing too is if you don't do it as vacation time, if you're paying the sick time as a separate thing, it does not need to be paid out as termination. So they give me this really small box to read your question, so I'm doing my best here. But that was from Mary. For employers that don't give paid time off until they have 1 year of service, do they need to change their policy and award this when the employees are hired? That's from Jennifer. Yes, Jennifer, you have to pay for the sick time. So you have to accrue the 1 hour per week basic. I'm assuming everybody works more than 35 hours for this part of the discussion. Yes, you need for your employees that are subject to this law, which would be basically people that work in Michigan that are not salaried. Salary to provide the administrative exemption or executive or outside sales exemption, and they work full time. Yes, you've got to accrue an hour a week for them. You can also front load that for them if you want right at hire, but now I'm spending your money. But yeah, you need to accrue that every week or every pay period. What's the next one? Is it a use it or lose it type of deal? If a driver's with us for 8 weeks, accruing 8 hours, and I'm going to say then is termed. This is from Emily. Do we owe a payout on it, even after he or she's gone, or no? No, you don't. It's not. It is totally use it or lose it. You do not owe that money out at termination. Hopefully, they're not going to pretend to be sick for a day first, and that's goofy too because if you don't think they're sick, you're getting to those documentation requirements, and this is where you get hung up because you're like, they're full of it. There's no way they're sick. I saw them yesterday. They were healthier than healthy. But if your documentation policy is that you only document after 3 days, which is a reasonable policy, and they call in sick for 1 day and then quit because they knew they had 8 hours, that they knew they had 8 sick hours, yeah, it's really crappy. But if you go ask for documentation without any other proof, you're asking to get sued. Again, better question for an attorney to speak authoritatively, but I'm telling you, that's how I see it happening. So yeah, it sucks that you got to pay that day to somebody who's probably a horrible driver and quitting, but it's cheaper than a lawsuit. Yeah, okay. What's Kathy asks? I love all the questions, by the way. That's awesome. Will you be emailing this webinar to us to view at a later date? And then it goes on. Yeah, Kathy, we're going to email this out to everybody. There's a couple things we're going to do. We're going to make a recording of this available to everybody, and we're going to email you the slides. And so I don't like hearing the sound of my own voice, so the slides are better for me, but for you guys, hopefully you can get through the recording. We're also going to update this. It's one of my plans is if things change, if we get some more definitive answers, we're going to update this and do another one. And say, Judy asks, is it payable after 90 days? Oh, whoops. I think it is payable after 90 days and not 60 as stated. Please clarify. I will look into that to make sure. I got to go through my notes, Judy. But what I'll do is when we send out the webinar slides, we will also clarify that for everybody. So I appreciate you bringing that up. Again, a lot of this stuff is so unknown, but I think that's something I should be able to look at pretty quickly. Wouldn't our hourly drivers follow the same rule of 1 week worked equals 1 hour accrued, like our OTR drivers? Or is it different because we pay by the hour? For your hourly drivers, you can accrue just like hourly employees. But if they work more than 35 hours a week, they're going to get that hour. But you could say for a driver that worked only 30 hours the 1 week, you can accrue part of an hour. I generally wouldn't screw around with it, and I just give them an hour every week because, I mean, if you have drivers that are working 30 hours a week, that's crazy anyway. That's pretty rare. Only in rare circumstances do you see that. At that point, drop them below 25 and you don't have to pay them at all. But I'm not suggesting any driver work less because we all are looking for drivers. Oh, thank you for sharing, for Brady. You're very, very welcome. We're glad we could help. I hope this provides value to everybody. I mean, that's why we're here. All these webinars that we do. And when you get the link to the recording for this, there's other webinars that we have there about driver recruiting and driver retention and a few other ones that you also will have access to at no charge. We just want to educate trucking companies, help them be better. Trucking's hard enough when you do it and you know all the rules. It just gets harder if you don't. So we're happy to try and help that out. Can we get a copy of the slideshow emailed from Albin? Absolutely, Albin. We're going to email that out with the answer to Judy's question about the 60 or 90 days. If we are calling it PTO and provide at least 40 hours a week, Marjorie wants to know, do we still need to accrue 1 hour per week or can we accrue it at 0.8 hours a week? Oh, so you're thinking 0.8 hours a week for 50 weeks is 40 hours, right? That's kind of the way that I'm reading that, Marjorie. I would say you're going to need to do an hour a week. If you don't front load it, you're going to need to do an hour a week because they have an hour. If somebody 6 months in, okay, let's say somebody works 26 weeks and they qualify, they work more than 35 hours each week. They'd have 26 hours available to them, not 26 times 8/10 of an hour. So you'd really need to do an hour a week for the first 40 weeks. Unfortunately, that's the way I read it. Okay, and then she asked another question. This might be the same question. If we calling it PTO, no, okay. Maureen wants to know if you give 40 hours and they use PTO before they are sick, do we have to give more sick days? No. No. That's the thing is you're giving them the 40 hours. They can use them however they want. Basically, what you're doing is you're giving them 40 sick hours and you're choosing to use them for other things, which if you call it sick/vacation, you're allowed to do. I think I caught everybody's questions. There might have been new ones that came in that I didn't see, so I'm trying to find them. I don't see any. If you have other questions, though, feel free to reach out. You probably will teach us some things too. So because again, this law is not settled. So we're hoping that we can get some finality on it. And like I said, we might revisit this topic again in a couple of months once we get more clarification or once a court case comes through or something like that. Hopefully with an actual attorney that's willing to talk about it and not bill me for it. That'd be great. So, well, thank you very much for attending. Feel free to follow up with other questions and comments. We look forward to your feedback on these webinars. We took the part of the winter off, but now that it's spring, we're going to start probably trying to do them every month again. Next month, we'll do another webinar. Towards the end of the month, we'll probably do another one. It might be about driver recruiting again. We've got a few that we can do, but we really look forward to helping the trucking community. We're glad to be a small part of it. So thank you very much for your time, and I hope you have a great rest of the day, and happy opening day of baseball to all of you.